is we want an update on George Floyd's case. So George Floyd's case, there's some activity going on, and I want to just kind of run you through what that looks like. So there were some headlines today that there is a motion to dismiss that was filed by Tou Thao, who was one of the officers who was involved in actually on the scene when George Floyd passed away, or was murdered essentially. So here's what's going on with this case. Now, when you're charged with a crime, when you're charged with a felony, one of the things that the government has to do is they have to prove what's called probable cause. In other words, there needs to be enough evidence there to say that we even can bring the charges. So it's not that you're guilty beyond a reasonable doubt. You hear that standard all the time in the movies. That's what a trial's for. That's when you get a jury, because the government has to gather the evidence, and they have to say there's enough evidence here to prove that you actually committed that very specific crime on this very specific day under these very specific conditions with these very specific facts. If the government can prove that, and they can prove that beyond a reasonable doubt, meaning if there's any doubt that's based in reason, then that person is not guilty. They got to do, that's their job. It's a tall task. It's a very difficult burden for them to overcome. Not really. They say that it is, but not really. Most people, most jurors, most judges, most prosecutors all presume our clients were guilty. This really high standard is kind of a bunch of nonsense. As soon as a jury walks in, they basically go, "Oh, that guy's guilty." They do that very frequently. It's very unfortunate, but that's part of sort of how our culture has been basically brainwashed to think that if you're sitting in the defense chair, you're automatically guilty. Cops are always right. Bad guys are always bad. It's very difficult to get people to actually listen to some evidence or think logically. But that's a topic for a separate day. But when we're talking about probable cause hearings, it's a much lower standard. So beyond a reasonable doubt, very, very high, very high burden for the government to hit. It's a much lower standard for probable cause. So in order for the government to just even start the criminal case against you, they have to show that it's kind of more likely than not, or there's enough evidence to say, we suspect that this other stuff happened. And so what Tou Thao's attorney is doing is saying there is no probable cause. There's no basis for this charge even to begin with, and therefore we're asking that it gets dismissed. Now the motion you can see here is somewhat long. I'm not going to spend a lot of time going through the entirety of it, but we can see here that, well, give me 1 second. Let me get this screen going. All right, so if we hop over here, you can see here that this was the motion. It was filed in the state of Minnesota, the county of Hennepin, in the 4th Judicial District, and it's going to the judge. They're saying right now they're asking for an order dismissing the charges that are filed against him because there's no probable cause. They said they're required to set forth certain facts, but they're asking that they both get dismissed because they're saying that Mr. Thao did not have the required mental state, meaning he was not of the right mindset. He was not intending to aid and abet Derek Chauvin, who's the other officer who put his knee on George Floyd's neck and actually killed him. There's no evidence that he was intending to aid and abet that. There is no probable cause as to what specific acts of Thao's furthered the commission of the underlying crime. So what did he do specifically that led to the death of George Floyd? And then they're asking for an order that says that all of this fails to establish the probable cause. And so, that's something that I think is going to be litigated. So this motion was not filed in Derek Chauvin's case. It was filed in Tou Thao's case, which is another interesting thing. So now it seems like these two parties are sort of pointing their fingers at one another. So Tou Thao is saying, I didn't do it. I was there, but I didn't do it. There's no probable cause. Everything that I did was legitimate. If we go through the actual, so what we saw was sort of a notice that a motion took place, but then we actually have the motion. We have the memorandum and the, wait, no, that's not it. That's not it. Okay, so basically the rest of the motion is just saying that they don't think that he did it. There's no justification for charging Tou Thao with any crimes. He was there. He used a lawful chokehold according to the police department manual, and he never woke up that day intending to go kill anybody. He also didn't know that the other people were intending to kill George Floyd. So what he's doing is he's drawing a pretty hard line in the sand and saying, I didn't do that stuff. Those guys did it. And this is an interesting thing that happens when you have co-defendants. So George Floyd, there were 4 officers. They were all at one point sort of leaning on him. We saw that imagery from the back side of the van when they were all on top of him. Tou Thao, what's this guy's name? Tou Thao says that he had nothing to do with the actual death, and he's got this big long memorandum that is explaining essentially what his position is. So they're going to have to litigate this. The prosecutors is going to file a response, basically opposing the motion to dismiss and saying, here's our basis for probable cause. In my opinion, they're going to find probable cause on this issue. This case will move forward. These charges are not going to get dismissed. A lot of this stuff is open to interpretation, so it's going to go forward, and there's going to be plea negotiations and stuff that take place further down the road. This is a pretty standard type of motion. When you're this early in a criminal case, you will see that people are filing these motions just almost as a matter of necessity. It's just kind of part of the template. If in certain situations you always want to challenge probable cause, because if you can win a case at this stage, everything gets thrown out afterwards. So this is kind of a standard operating procedure here. There are some people on Twitter and on the news sites saying, oh my gosh, they're asking to dismiss the charges. What does this mean? I don't think it's that big of a deal, quite frankly. I think the government is going to respond. They're going to lay out why the probable cause exists. I think they're going to be correct that the probable cause does exist, that he at least contributed. He did aid. He did sort of abet these other officers in their conduct, which resulted in the death of George Floyd. And so I don't think that anything's going to happen on that basis, but we will see. Now, the other interesting thing that we learned is that the government is actually trying to join these cases together. So you can see here, which is actually, this is something that I was not aware of, but all of the documents are now on the Minnesota government's court website. So you can see here, this is all of them. This is for Derek Chauvin. So you can just go right there. This is all public record. You can go to Minnesota Judicial Branch, and there's a link to high profile cases. You can sign up and receive the notes. But you can see here, Tou Thao filed his, and a similar motion is not here for Derek Chauvin. But what we do have is a notice of motion and a motion for joinder. And what does that mean? Well, if you look here, you're going to see that all of these different cases, these are all different cases, right? We've Derek Chauvin, we've got Alexander Kung, we've got Thomas Lane, we've got Tou Thao. All separate cases, all separate case numbers. They've been charged differently. There are different people. And what this motion is doing is it's saying, what we saw previously was Tou Thao was saying, basically, I'm not a part of this. I have nothing to do with this. It's those 3 other guys. They're the ones who did it. Derek did it, and the other 2 who were involved, they did it. I had nothing to do with it. Judge me on my own activity. Judge me on what I did on my own. Which there's a lot of value in that, right? Because if you can start separating yourself out from that, whatever happens to those other guys, good luck to them. They're on their own. But me as a defendant, I want my day in court. I don't want to be connected to those other guys, especially on this case. This is a disaster of public relations for these guys. You get a jury. These guys all might go to prison forever. As I think Derek Chauvin is in the worst situation, but I don't think that's happening for these other guys. So Tou Thao is saying, nope, we're gonna blame the other people. Had nothing to do with us. Go get them. The government is coming back and saying, no. We're going to join these cases. We want to move all of these things together because it's surrounding the same incident. They were all involved in the same death. The allegations all stem from the same murder of one individual, George Floyd. They all relate directly to him. So why do we need to have 4 different trials? Why do we need to separate these things and present all of the evidence to one jury for Derek, present all of the evidence for another one against Tou, another one against the other 2 officers? Why do we need to do that? Why don't we just consolidate them? And then that way, what they're going to try to do is connect the dots. They're then going to say, okay, so Officer 1 showed up and did this. Officer 2 showed up and did this. Officer 3, Derek, sat down, put his neck on a knee on George's neck. George died. Officer 4, Tou Thao, did this. All these things. Tie them all together so that you can kind of judge the case as a totality. They all were involved in this thing. Neither one of them, and none of them, can really extricate themselves from liability, from culpability, because they were all involved in it. They all did. They were all parts of what resulted in his death. Maybe if it was just one officer there and the other 3 weren't keeping the crowd back or ignoring their pleas. If you remember the video, I mean, it's a brutal video to watch, but there are bystanders who were saying, he's dying, man. What are you doing? Like he's dying. He can't breathe. He's telling you, he's literally, you're killing him. Hello. And those other officers were pushing those people back and just ignoring them. So maybe they contributed to his actual death. Maybe if it was just one officer, the public would have said, bro, and pushed him off and maybe picked him up and done something to save his life. But they didn't. They were there. So they contributed to it. It's just like if you are robbing a bank, you and your 3 friends are robbing a bank. They go in and rob the bank. You sit in the car and you're going to drive them. You're the getaway driver. Well, they robbed the bank. You didn't rob the bank, but you're still culpable for that thing. You're still a bank robber just because you were there and you didn't pull the gun out and point it at the clerk and fill the bag full of cash. That doesn't mean that you didn't do anything wrong. You were still there. You were part of this scheme. You were part of the entire operation. So in the totality of circumstances, the government wants to keep these things together and not let the defendants point their fingers at each other. They're saying, no. It's all 4 of you. You're all responsible for this thing. And they're going to move forward accordingly. So it's going to be interesting to continue to watch. The next scheduling order says that we've got new updates are due by September 8th. So the defendants shall file their responsive memoranda and their supporting materials. So the government said, we want to join these cases together. The court is saying, all right, defense, what do you guys have to say about that? And the defense, all 4 of them are going to have to respond and make their own arguments for that. So we're going to see what those look like. Are they really pointing their fingers at each other? Why are they going to not want these cases to be joined? We'll find that out shortly. The motions and the memoranda are due by September 8th. And then the hearing the briefing will be discussed at the September 11th hearing. So that's just under a month away. We're going to see that. And this comes from Judge Peter K. Hill from the state of Minnesota.